Hello, I'm Dane Frew, and welcome to another episode of Divorce Unplugged. Geoff, thanks for being here again with us. We're 4 episodes in, and we've had some good feedback around the podcast so far, particularly around your health tips. They've been the feedback there's been very positive.
It has, and I'm pleased that people are getting the opportunity to hear and listen to those little tips that I throw out there.
So I want to start off with a little bit of a random one at the moment. What was your favourite TV show growing up as a kid, or favourite time you used to sit down and watch your...
Well, I think most afternoons after school, when I was younger, it was Gilligan's Island, and then, of course, Doctor Who would come on, and I was always a big fan of that. But I always loved shows where there was some science or there was things being explained as well.
Yeah, well, I was a little bit... Mine was probably South Park or The Simpsons, so that's probably shows where I'm at. But South Park on SBS was a favourite. Speaking of shows on SBS, I was never really good at science as a kid, but there was a show by the name of Mythbusters, which was quite entertaining, where a couple of guys and a lot of the time they would try and bust myths based on things that happened in movies or TV shows, where they would get together and work out why something would happen the way that it should happen, or the way that it happened on the show or the movie. And that was always quite an interesting show. Did you ever watch that?
I did. I've delved into quite a few episodes of Mythbusters over the years.
Good. So I thought we could tackle that today, do a bit of myth busting in family law. I'm sure there's a few myths out there that you would come across from speaking to people that we could perhaps get into.
I think I genuinely believe that in the 30 years that I've been talking to people about family law matters, that there are lots of pub conversations, if you want to call them that suggest one thing might be the case in relation to a family law matter, but probably when you drill down on it, it's not actually the case.
So I'll start with a common one that you hear of a lot, I guess. So couples who separate, are their assets and liabilities just automatically divided equally?
Well, one of the most common questions we get is exactly that. And the answer is no. A 50-50 division does occur, but it's not the norm. You have to go back to some first principles to look at what would be a fair and just division of assets.
So what is fair, and what factors are most important?
I think if you really drill down on it and try and explain it in plain English, the things that are important are, well, look, what did the parties have when they first got together? How long were they together for? Did they get any individual lump sums along the way? For example, maybe a personal injury payment or an inheritance, which may have added to their assets in an unusual way. And then when they separate, what their future needs might be.
So you said before you've been having these conversations with people for over 30 years. How often in that time period have you actually seen a 50-50 split?
Look, I think 50-50 splits maybe happen 50% of the time, but certainly there are quite often adjustments. And even when people want to divide things 50-50 in a practical sense, when you're trying to say, I would like to keep a car and you can keep some superannuation in a car, it inevitably ends up slightly different to 50-50. It might even be 52-48, but for practical purposes, the parties have agreed to as close as possible to an equal distribution.
So back to the first question, would you say the myth is true or busted?
Look, I think it's busted. It's not the case that a 50-50 is the norm or is compulsory. I think the only time you would really want to say that that's the truth is in a very long relationship. So if you're together for 40 years, you've really got to convince a court that it's not an equal distribution.
Yep. All right. Second one. If you get a financial windfall after you have separated, that you'll get to keep that separate from any other property to be divided?
Well, that's an interesting one. The courts have loved to play with this question over lots of years now, and what we've found is that we don't know, in the sense that the court has two ways of trying to deal with what they call a windfall. So if you get a $1 million inheritance and the parties themselves, when they separated 12 months before, only had $1 million in assets, it's a pretty big lump sum of money. So the court has looked at things like windfalls in one of two ways. Firstly, they can add it to the asset pool that they already have, which is the $1 million I mentioned in my example. So you've got $2 million in assets, but then take into account that how it came in. Was it an inheritance or was it just a lotto win? And then divide the on a percentage basis the total pool in a certain way, but probably favouring the person who got the windfall. Or, oddly enough, the court's also taken the approach to say, look, I'm going to keep the windfall separate, that $1 million separate that you just inherited, but because you've got this big resource now, I'm not going to give you 50-50 on the other $1 million that the two of you had at separation. So what they do is they might say, well, look, if it was the husband who inherited the $1 million, well, the wife might get 70% of the original $1 million they had. So she might get 700,000. The husband gets 300,000, but he gets to keep his inheritance of $1 million. So that they've adopted two completely different approaches, and it's very difficult to actually work out which one is the way the court would go.
So how do you know, or how does the court know, and how do they deal with when they're negotiating a property settlement, then how do they take that windfall into account?
Well, in that sense, they either have to add it to the asset pool or they've got to then treat it as a resource. And the closer it is to the separation date, the more likely they are to include it in the original asset pool. If it's a couple of years afterwards, they probably won't. And they look at the size of it relative to the assets, in my example before, the $1 million each of the windfall and the asset pool. But if the windfall's 100,000 that you want to, playing Keno, and you've got a $5 million asset pool, they might just say, well, look, good luck. You can keep that, but we'll still divide up the other assets and give the wife an extra 2% of the $5 million. It really does vary based on the individual circumstances.
All right, so overall, the keeping of the windfall, true or busted?
I say busted, because you don't expect that it won't impact your property settlement.
All right, okay, so another one. If a party is married overseas, they cannot get divorced in Australia.
I call busted straight away on that. We do many, many divorces where the parties are married all over the world. There's no jurisdiction where you are married in the world where you can't get a divorce in Australia. So there's some jurisdictional questions about bringing your application in Australia. For example, you must be an Australian citizen or have become an Australian citizen, or generally speaking have a permanent right to reside in Australia to bring your application for a divorce. So if you're just visiting here for a couple of weeks and you were married in the United States, that doesn't give you the right to file for divorce in Australia. So you've got to get over those couple of initial hurdles to get there, but an overseas marriage of itself doesn't preclude you from getting divorced.
So not an Australian citizen, not married in Australia, can you get divorced here?
Yes, but you've got to show that you've essentially either lived here for more than 12 months and have an ongoing right to continue to live here, or have some form of residency, a permanent residency visa, for example, so that shows that you have an ongoing right to reside here. So they are the triggers for an overseas non-citizen to get divorced.
All right, I've got one more for you on that same topic. What about if they were married in Australia but now living overseas?
That happens a bit for us as well. So we quite often have two scenarios, I think. One is the expat Australian who might be working in the UAE or in the UK, who has separated and wants to get a divorce back in their home country, so to speak, back where they were married. They're perfectly entitled to get a divorce, notwithstanding they're not residing in Australia. The other one, of course, is where we have a non-Australian who wants to get a divorce but is not living again in Australia. That's quite difficult. So if you're a Singaporean citizen who happened to get married in Australia, you probably will struggle to file for a divorce in Australia because you don't meet the jurisdiction. It's not too much different in a practical sense to an Australian couple to go to Las Vegas and get married on a whim and then come back and decide that they can't live happily ever after. They're not entitled necessarily to go back to the US and do the divorce over there because of the jurisdictional problem that they'd face.
So fair to say they're busted. Sounds like you can get through no matter what the situation. Just takes a little bit more work. Sometimes
a bit more work, no doubt. Yeah. And there's only a few exceptions where you won't be able to get divorced.
Yeah. All right. So back to property division. So I guess there's a common query that if you own an asset, say a car or a house before you enter a relationship, that automatically you get to keep that when or if you separate.
All right. Well, that's a really common question. So we start with, say, the big asset like a house or a car. The general theory is once you have entered into a permanent relationship, either de facto or married relationship, and basically those assets form part of the overall asset pool that a court would consider in how to divide. Now, by that I mean if you come into a relationship of, say, of 10 years and you bring a house into it and break up at the end of 10 years, then, well, that asset is part of the overall assets that you've built up along the way. You might have paid down a mortgage, and the court will deal with that property just like it will deal with all the other assets you bought along the way and work out what's a fair thing to happen with it.
So it's actually not the case.
Well,
So, sorry to cut you off, but so what about any other personal items, say like artwork or sporting equipment?
all right, let's just deal with those as well. So if I just finish off in relation to the big items, the house and car, what the court, in my experience, tends to do is it looks at, if you brought it in, then they will give genuine consideration to you, if it's possible, in dividing up the assets fairly and you keeping the things you might have already had. Like, for example, the family farm. But when you get down to the smaller items, your personal effects, sporting equipment, your golf clubs, generally speaking, the court will work very hard to make sure that your smaller chattels are things that you retain because they're personal to you. Artwork, for example.
What about jewellery?
Jewelry is interesting. I think I would have, in my experience, in nearly 100% of cases, if you've got some jewellery, even if it's show jewellery and things like that, you will be entitled to retain that. If it's very expensive jewellery, if you've been given a $25,000 diamond ring, it could form part of the overall assets and be kept. If the wife keeps it, it form part of her overall assets. But she will be given first choice to keep it.
What about gifts from family or third parties? How does that work?
Oh, gifts always cause some consternation because if I'm given a television, then as a gift, say it's a wedding gift, and who gave it to me, and we break up within a short distance afterwards. Sometimes was the gift given to both people? Was the gift given just to one? So if it's a birthday gift or something like that, then it should be retained by the recipient. But if it's a general overall gift, like a wedding gift given to both, then the court will deal with it as it sees fit. It might be that if it's the brother of the husband gave them a TV for their wedding, well, probably. Look, I think the husband would get to keep the TV if he really wants it.
You know, a random one for my wife and I's engagement party, we got 3 cake stands. We don't even bake or really eat cake. So if we were to separate, Cal, you can have the cake stands if we've still got them somewhere. Anyway, I've digressed. Let's do a snappy one. What about, can a husband make his wife or force his wife when they separate to stop using his surname that they've adopted when they were married?
Well, let's say Mr. Smith marries Ms. Jones and they become Mr. and Mrs. Smith. If they separate and they even get divorced, the answer is no. The wife is entitled to continue to use the name Smith. So some people do get a bee in their bonnet about that, but there is no law or legislation in Australia that can compel the wife who has taken someone else's name on marriage to change it back.
Okay. What about if parties enter a relationship and want to have certainty about how the assets are divided? This is possible in Australia, or are prenuptial agreements only available in the US or overseas?
Well, I think the US pioneered what we call prenuptial agreements.
You hear a lot about the movies, don't you? They'll prenup and
yes,
celebrities and different things like that.
Well, they talk about things like alimony and all sorts of
Yeah.
interesting words that we use different phrases for. But whilst they pioneered the concept of trying to have some certainty in a relationship, in Australia, for a number of years now, the Family Law Act has added pieces to it that cover both relationships when you're contemplating marriage or are married, and also relationships even if you don't. So if you're wanting to become a de facto couple, you can in fact now contract between you by doing a document called a binding financial agreement that sets out what will happen in the event of a separation or even a death.
So you can get a prenup in Australia. That's not a myth.
That is not a myth.
That is finally got something.
It is true. You've got some hoops to jump through
Yep.
to do one because the document has to be in a certain form, and both parties need independent legal advice about the advantages and disadvantages of doing that agreement. But if you can jump through those hurdles and it's properly completed, then it will be a binding document and you can't go to court and change it.
So let's do another quick one, and this one's an interesting one. So I've been told that a husband can request back the wedding ring and the engagement ring when separation occurs. Is that true?
Well, depends. Again,
It always depends.
It always depends. So let's break it down into a couple of different scenarios and how the courts have treated it. So if I give my betrothed an engagement ring and there's two actual scenarios that then occur, which is a little bit confusing. So if we don't live together and and then the wife to be breaks it off, the general principle is that the engagement ring should be returned back to the person who gave it, because it's what they call a conditional gift. So giving a conditional gift means that this is a gift. I'm giving you a ring on the promise that we're going to get married. We're now not getting married. I'm entitled to get it back. Where it gets confusing is in relation to if I then start living together with the person I get engaged with, because then by definition you become a de facto couple. And when you're a de facto couple, as I've said, all assets fall into the pot to be divided. So there's no absolute certainty that the engagement ring would come back to the husband in the case of the breaking up off of the relationship. And sometimes the court will look at, well, they may even delve into the circumstances of who broke it off as to whether the ring would be returned.
What about if it was a ring that was passed down from the family, or it's a family heirloom on the husband's side?
Well, in that case, again, the court would lean towards having an heirloom come back, although there's some case law that in certain circumstances they've said no, because of that they were then subsequently married, for example, for an extended period, and even though it might have been the husband's grandmother's ring, the wife has had it as part of her assets for 15 or 20 years, and there's no requirement to give it back.
Well, I said one last quick one. That wasn't so quick, but I guess it's always complex.
It's not a snappy topic,
No.
And we sort of ignored the issue of wedding ring, the wedding ring itself, as opposed to the engagement ring. The wedding ring is because you, as I said in my example before, it's not a conditional gift, because you don't get a wedding ring until you're married. So the condition is finished, the marriage has occurred, so it becomes an asset that falls into the asset pool. I would have to say that I would be 99% confident that the court would allow the wife to retain a wedding ring, because it's a personal effect, as we talked about before.
Yep.
But it does have, if it has again a significant value, it could fall onto her side of the equation in terms of being valued on her side of the asset pool, so to speak.
All right. Well, thanks for helping us clear up those myths. Now, as we said at the top, this was the listeners' favourite, or one of the favourite parts of the podcast, were your tips on health. And I think back, I think it was episode 1, you spoke about the health benefits of coffee, and you did mention about when you should potentially have your last cup of coffee if you're a coffee drinker, so it wouldn't affect your sleep. What about alcohol and sleep? So there's a bit of talking about myths, a bit of a myth out there that a nightcap is good for you and can help you sleep a little sounder through the night. Being an avid reader and researcher on all things health and wellbeing, of what's the science say behind that you've read and seen?
Well, I'll firstly talk about, before I talk about the science, I know people in my personal circle who believe that they need a couple of drinks, particularly before going to work on a Monday.
What, in the morning? In the morning?
No. So let's say it's
instead of a coffee, they're having a nip of whiskey.
No, but I'm thinking more Sunday afternoon, Sunday evening, so that they don't think about work too much before they go racing into work on a Monday. But does that really work? Well, what does the science say? So you've got some learned scholars out there who have been writing about this for a while. There's people called Peter Attia, who's a very well-renowned author, doctor, who looks at the science of these things. He, for example, points out that alcohol is a sleep killer, I'll call it, for a couple of reasons. Now, if you look at the science of it, whilst alcohol can help you fall asleep, for example, if you go out and you have half a dozen beverages and then you get home and collapse into bed and poof, you're off to sleep in a few seconds, it has two really negative impacts. One is that when you have alcohol in your system while you're sleeping, it doesn't allow you to get into what they call the deep REM sleep, which is the really restful recovery sleep that you need every day, if you can have it. And the other problem you have is it tends to raise your body temperature. So when you wake up at 3 a.m. in the morning thrashing around feeling a bit sweaty and hot, it's because the alcohol's kept your body temperature higher than it would normally. And
that makes sense.
the other interesting thing is most people say, oh, geez, I had some dreams last night after they've had a few drinks. And the reason for that, as the science tells me, is that because you don't go into as deep a sleep, you tend to have your dreams later in your sleep cycle. So instead of having that at 2 a.m. when you're normally sound asleep. You might have it at 5 o'clock in the morning. You have a vivid dream, and at that stage you're waking up, and that's why you're more likely to remember it and actually say, "Whoa, why did I drive that car off a cliff?" It's because I had that alcohol the night before, and I actually remember driving the car. So I think, in terms of myth busting, I think that alcohol helping you have a good night's sleep is a genuine myth, and all the scientists will say, look, if you can avoid having too many nightcaps, or at least allow it to get out of your system before you go to sleep, will help you have the best night's sleep you can.
Interesting. All right. Well, thanks for that. That was an interesting episode. Doing some myth busting. It was interesting, and I'm sure everyone will enjoy listening and watching.
Oh, look, it was a pleasure to talk about these topics, and I think a number of them are really important to get an understanding of, because in the sad time when people separate, they've got to have the right information. So I'm pleased that we've been able to bust a few myths today.
Yep, it's been fun. All right, thanks again for joining us, and we'll see everyone again next time.
It's been a pleasure, Dane. Thanks very much.
Thanks, Geoff.